delivered a monumental victory for the Constitution, the separation of powers, and the rule of law in striking down the excessive use of nationwide injunctions to interfere with the normal functioning of the executive branch.
That's the Supreme Court handing the Trump administration a pretty major win Friday, limiting district court judges from issuing nationwide injunctions. For legal analysis, let's bring in Constitution Accountability Center President Elizabeth Wydra and constitutional attorney Mark Smith. Guys, thanks for joining us this afternoon. Elizabeth, how significant is what the Supreme Court did? Could they have gone further, or is this essentially sort of a compromised version of limiting what local or more district court judges can do?
So this is an extremely significant decision. First, I want to say, it's not a ruling on the merits of President Trump's birthright citizenship executive order. It seemed that there was a majority, even among the conservative justices, who were skeptical of the birthright citizenship order's constitutionality. But nonetheless, this is a very important ruling because it limits the ability of courts to safeguard the rights of all individuals unless we each get our own attorney, file our own lawsuits, or can get over the substantial hurdles to certify a class action. And, presidents of both parties have complained about nationwide injunctions. But from my perspective, I think what this really does is make all of us less safe in the protection of our individual rights and liberties protected in the Constitution.
Mark, what do you think about that? I mean, you've got a number of critics out there who say that this is, incredibly damaging. It allows the executive to make these orders that make it very difficult to challenge. Of course, on the other hand, you've got those who say that you just can't have a federal judge in a particular district issuing these nationwide policies.
Well, to begin with, this decision reaffirms Donald Trump's signature achievement in his first term, which is to get the United States Supreme Court to follow the Constitution as it was written, as it was understood. That is the single biggest achievement of Donald Trump's first term, and it's a reaffirmation that remains true today. With that said, the United States Constitution, which specifically says that federal courts under Article 3 are only allowed to legally hear what are known as cases and controversies. Those are actual disputes between actual people that are actually in front of the court. What was going on here with these rogue district court judges, Rich, is that you had these local judges that were essentially engaging in legislation from the bench, say that, yeah, I may have 5 people in front of me in a case, but I'm going to enter an order that's so broad that it prevents the President of the United States from acting in a certain way all across the country as applied to 360 million Americans, even though I'm only dealing with a handful of people in my courtroom. And that was an abuse of the process, and the Supreme Court stepped up and says no more.
Now, Elizabeth, you mentioned it earlier. Part of this was all brought because of a challenge to the president's executive order on birthright citizenship. The Supreme Court essentially punted on that issue for now. What's up next for that order? How does the country comply with that? And is the Supreme Court eventually going to decide on that case?
Yes, for sure. So the merits of the birthright citizenship order were not before the court. This was just a decision on the injunction, the scope of the injunction. But I do foresee the substance of the birthright citizenship order getting to the Supreme Court. And I think when it does, I think that the court, even the conservative justices on the court, will reaffirm the guarantee of equal citizenship at birth for all, including children of undocumented immigrants if they're born within this country. But the question of remedy, which is really what this is about, there's a constitutional violation. What can the court do to make sure that individual rights are protected? That's really what is going to be the problem going forward, because as the states who are plaintiffs in these suits have argued, and they will continue to argue when the case, as the Supreme Court has sent it back down to the lower court, the lower courts consider it, people move across state lines. People are, we are free to travel in this country, and our rights shouldn't depend on which zip code or which state boundary we're in. We all have these individual rights under the Constitution. And so that's going to be really the issue going forward when we're talking about remedies for constitutional violations.
Mark, we don't often get a very good look into the inner workings of the Supreme Court, but you had some pretty contentious back and forth ongoing in text here. This is from Justice Amy Coney Barrett in her decision here on Justice Jackson's dissent. She writes, quote, "We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary." Have you seen such a personal interjection in a decision like this before?
Well, Richard, really is an extraordinary statement against Justice Jackson. Keep in mind, there are 9 justices on the Supreme Court. Justice Jackson wrote that dissent by herself, which means that even the so-called liberal justices, Sotomayor and Kagan, did not agree with what Justice Jackson said. So in addition to these 6 so-called conservative originalist justices disagreeing with her in a very clear and aggressive way, you also had the liberals refusing to sign on to that dissent. Because basically, if you read Justice Brown Jackson's dissent, essentially what it is that the courts get to do whatever they think is according to their view of the law, not recognizing the fact that the President of the United States and all people that work for the President of the United States also swear an oath to uphold the Constitution. And if there's a dispute about what the constitutional text means or some other issue, well, then that's up for the courts to resolve it. But that doesn't necessarily mean that the courts are always right. And that's what the Supreme Court was saying. And basically, Justice Brown Jackson's dissent is a classic example of the old-fashioned liberal judicial activism, which is if it advances the progressive cause, it's good. If it doesn't, it's bad, and you rule accordingly. That's not how the Supreme Court does it. They're a rule of law court. And again, another thanks to President Trump for making that happen with his appointments to the Supreme Court during his first term.
All right, Mark Smith, Elizabeth Wydra, thanks for joining us this afternoon.
Thanks, Rich.
Hey everyone, I'm Emily Campagno. Catch me and my co-hosts Harris Faulkner and Kaylee McEnany on Outnumbered every weekday at 12 p.m. Eastern, or set your DVR. Also, don't forget to subscribe to the Fox News YouTube page for daily highlights.